Here's a scenario that should bother you. Maria, a software developer, emails a startup CEO and says she'll build their MVP for $95,000 in 6 months. The CEO writes back the same day, agreed, but we need it done in 4 months. Maria says nothing. She just starts working, finishes in 5 months. The startup refuses to pay. They say there was never a deal. So who's right? That one story contains every major question in contract law. Was there an offer? Was there acceptance? Does silence count? Is there a writing problem? And what does Maria actually get if she wins? That's what this video is about. Buckle up, this one's going to change how you think. I'm going to walk you through the complete contracts pipeline: formation, defenses, terms, performance, breach, and remedies, in the order you actually need to think about them. Whether you're studying for the California bar or you're a founder who's tired of getting burned by agreements that fall apart, the structure here is what saves you. The doctrine itself isn't that complicated, but running it in the right sequence is where people go wrong. Contracts appears on the California bar exam in some form almost every cycle. It shows up as a standalone essay, it gets paired with remedies more than any other combination, and about 25 of the 175 scored multiple choice questions on the MBE are contracts questions. So the same organizational skeleton you need for the essay is also the one that carries you through the multiple choice section. And both formats reward running the analysis in order without skipping gates. 7 steps. Step 1 is applicable law, UCC, or common law. Step 2 is formation, offer, acceptance, consideration. Step 3 is statute of frauds. Does the contract need to be in writing? Step 4 is defenses. Is the contract void or voidable for some reason? Step 5 is terms. What does the contract actually require? Step 6 is performance and breach. Did someone fail, and does that failure matter? And step 7 is remedies. What does the injured party actually recover? You run those steps in that order every single time, and you don't jump to step 6 just because it's the interesting part. If you've been doing this for a while, you know the pipeline has a gating function, so no contract means no breach. And without a breach, remedies analysis is premature. If the statute of frauds kills the contract, you don't even get to performance, though you should know that a contract failing the statute of frauds is unenforceable, not necessarily void, so there's still a quasi-contractual recovery argument on the table. Each gate opens based on what happened at the gate before it, and examiners plant facts that either satisfy or defeat a gate because they want to see if you catch it. This is the #1 mistake I see: students treating the early steps like a formality and rushing to whatever looks like the main issue. Say a fact pattern has a 1-year service deal made over the phone. The drama in the fact pattern might look like anticipatory repudiation, but the statute of frauds issue at step 3 could kill the whole claim before you ever get there. Running the pipeline in order catches that, so skip ahead and you're writing a perfect analysis of the wrong question. Now let's get into formation. Under both common law and the UCC, forming a contract requires a valid offer, a valid acceptance, and consideration. California Civil Code, Section 1550, breaks this into 4 elements: parties capable of contracting, their consent, a lawful object, and sufficient cause or consideration. Intent is judged objectively, and under the objective theory of contracts, which comes up in the bar prep classic Lucy v. Zemer, what matters is how a reasonable person would read the outward manifestations of the parties, not what someone secretly thought. So if you act like you're making a deal, you're bound by it. An offer needs to be specific enough that acceptance creates a contract. Under common law, all the material terms have to be there: quantity, price, parties, subject matter, time of performance. Under the UCC, you only need quantity and subject matter because price, delivery time, and other terms can be filled in by the code's gap filler provisions. Advertisements almost never qualify as offers under either standard. They're invitations to deal, and an offer can be revoked anytime before acceptance, unless it's an option contract backed by consideration or a UCC firm offer, which is a signed written promise from a merchant to keep an offer open, binding for up to 90 days with no consideration required. Acceptance under common law requires a precise mirror of the offer, so any added or changed term voids acceptance and converts the response into a counter-offer. Under the UCC's Battle of the Forms rule, California Commercial Code Section 2207, an acceptance with additional or different terms is still an effective acceptance unless the offeree conditions their acceptance on agreement to the new terms. Between merchants, those additional terms automatically become part of the contract unless they materially alter it, the offer expressly limited acceptance to its own terms, or the offerer objects within a reasonable time. Under common law, you are bound to the original terms, but under the UCC, additional terms survive unless one of those 3 exceptions applies. Back to Maria. Her email was an offer: specific price, specific deliverable, specific timeline. The CEO's response added a new term, 4 months instead of 6, which made it a counteroffer, not an acceptance. Maria never explicitly agreed to 4 months. She just started working. So did silence plus performance create a contract? Probably yes. Under the objective theory, starting work looks like acceptance, but on what terms? Maria's original 6-month timeline or the CEO's 4-month counter? Sounds familiar, right? Consideration is the bargain for exchange: a promise, an act, or a forbearance given in exchange for a promise. 2 rules matter here. First, past consideration is no consideration at all because the exchange was already complete before the promise was made, so any payment promised after the work is done carries no enforceable consideration. Second, the pre-existing duty rule says a promise to do something you're already legally obligated to do isn't new consideration under common law. A contractor already under contract who demands extra money to finish the job gets no enforceable promise of extra pay if the owner agrees because the modification fails since the contractor offered nothing new. Under the UCC, contract modifications don't require new consideration. They just need to be in good faith, so the body of law you're operating under determines the answer. That's the difference right there. Which brings us to the threshold question you have to answer before anything else. UCC or common law? The UCC governs contracts for the sale of goods, and California Commercial Code Section 2105 defines goods as tangible, movable personal property. Common law governs everything else: services, real property, employment, insurance, intellectual property licenses. Maria's software development deal is a services contract, so common law governs, which means the mirror image rule applies to her acceptance question, not the battle of the forms. It doesn't have to be that complicated, seriously. A deal that involves both goods and services needs a choice of law analysis, and California recognizes two tests. The predominant purpose test looks at the whole contract and asks whether its primary purpose is goods or services. A caterer who provides food and event planning is probably providing a services contract overall, even though food is a good. The gravamen test is the minority approach and looks at the specific part of the contract at issue in the dispute. Same caterer, but a claim about food quality might be analyzed under the UCC even if the overall contract is a services deal. California courts have used both, so on a bar essay, you raise both and apply them to the facts. Now the statute of frauds. The mnemonic is my legs. Marriage, contracts that can't be performed within 1 year, land, executors promise to pay estate debts personally, guarantee, and sale of goods over $500. Under California Civil Code Section 1624, those categories require a signed writing to be enforceable. And under California Commercial Code Section 2201, goods contracts worth $500 or more need a writing that indicates a contract was made and states the quantity. Triggering my legs without a writing leaves the contract unenforceable, but quasi-contractual recovery is still potentially available. And there are exceptions: full performance, partial performance for goods contracts, promissory estoppel in some jurisdictions that can save a contract that doesn't have the required writing. People overcomplicate this like crazy. After you've confirmed formation and cleared the statute of frauds, you check defenses. Formation defenses can void or voidable a contract even after it looks complete, and duress, fraudulent misrepresentation, mutual mistake, incapacity, and illegality are all in this bucket. Enforcement defenses include unconscionability, where a contract is so one-sided a court won't enforce it, and impossibility and frustration of purpose, which excuse performance when something outside the party's control makes the contract impossible or pointless to perform. A void contract has no legal effect at all, while a voidable contract can be affirmed or rescinded by the injured party. Then you get to breach. Under common law, the standard is substantial performance, which means if a party substantially complies with the contract's terms, they've performed, even if they didn't hit every detail perfectly. Under the UCC, the perfect tender rule applies. So if the seller delivers goods that fail to conform to the contract in any way, the buyer can reject all the goods, accept all of them, or accept any commercial unit and reject the rest. Under the UCC, sellers must hit perfect tender, which is a stricter standard than substantial performance. A material breach terminates the contract and excuses the non-breaching party from performing, while a minor breach gives rise to damages only and the other side still has to perform. Let's go. Anticipatory repudiation is worth flagging separately. If a party clearly communicates before the performance date that they won't perform, the non-breaching party doesn't have to wait. They can treat it as a present breach, stop their own performance, and sue immediately. They can also treat the repudiation as an offer to rescind and accept it, or they can wait and see if the repudiating party changes course before the performance date. Remedies split into legal and equitable. On the legal side, expectation damages put the injured party in the position they'd have been in if the contract had been performed. That's lost profits plus incidental costs minus costs saved. Reliance damages cover expenses the injured party incurred in reliance on the contract. Restitution prevents unjust enrichment by giving back the benefit conferred on the breaching party. Consequential damages cover losses beyond the direct expectation measure, but only if those losses were foreseeable to both parties at the time of contracting. That's the Hadley v. Baxendale standard. Specific performance is available for unique goods, real estate, and sometimes specialized services, situations where money damages leave the plaintiff short. But courts won't order specific performance of personal service contracts due to involuntary servitude concerns. Subscribe if you want more stuff like this. If you ever need to find someone or run a background check, go to Scraper City. If you want to grow your law firm using outbound techniques where legally allowed, check out Galadon Gold. And to automatically grow on Twitter and X, use Tweetloft. The next video is coming up now.